Solicitors/lawyers. What's the worst case of "you should have mentioned this sooner" you've experienced? My first ever hearing in front of a judge as an attorney was a Social Security disability appeal. My client had been crushed at work a few years ago and his entire left side of his body was mangled. He had PTSD as well from seeing his dad unalive himself as a kid. Loads of mental health issues and physical ones as well. Just my luck, I get the biggest jerk the SSA has to offer. It's sort of an unspoken rule that you don't interrupt someone's opening statement. You don't make objections and you don't interrupt. Well, I get 3 sentences into my opening and I was listing his conditions. And the judge screams over me. "You forgot one. What about the drug abuse disorder? When was the last time your client did drugs?" I froze for half a second, glared at said client, and said, "Well, Your Honor, I didn't mention that, similar to how I didn't mention his prediabetes and seasonal allergies. It isn't relevant to his ability to work as he hasn't abused drugs in several years. Additionally, he admitted that he used drugs to cope with his mental health disorders, which he has taken much better control of since he began counseling." I was damn proud of that response. My client won the case. I called to tell him. His girlfriend answered and informed me that he was in jail for the next 36 months for stealing a car. We now have a Discord. Check out the server in the link in the description. Story 2. A person involved in a motorcycle accident who sustained legitimate but not serious injuries. CCTV showed the incident. They were very much not at fault. They decided this was their big payday. Claimed they could barely walk, had PTSD, serious back trouble, would never work again, the whole 9 yards. They neglected to tell their lawyer that they had been A. working a manual labor job, B. riding motorcycles again, C. did a bungee jump. All of which were caught on video / they documented via social media. They did not get the multi-million-pound settlement payment they expected, and were pursued for fraud. It was a fun phone call after we'd sent the tape full of evidence. Story 3. Special education case. Mother and school were fighting about services. We got new assessments that backed up the mother's claims. Local school didn't have the right services, so we arranged a transfer to a larger school not too far away. Good public transit route and some extracurriculars the kid was excited about. She goes to enroll him in school. Says they have a problem with paperwork. Thinking the transfer info just didn't get there yet, I take a copy and head down there. No, they won't enroll him because it was not his legal name, and she is not his legal mom. Turns out she was the BFF of a mother who is pregnant and about to be incarcerated for drug trafficking. BFF says, "Can you take my baby while I'm in jail? I'll get him as soon as I'm out." She and husband say sure. They sign a piece of notebook paper. 12 years later, SMH. You have to think, how did they manage to navigate school and medical stuff for 12 years with no legal custody paperwork? They had just been using an assumed last name of the pseudo-adoptive couple, and, like me, no one had asked. Was only that the school had moved to an online system that checked social security numbers against other databases that it was caught. Anyway, bio mom and dad were still alive and still in a lot of trouble. They consented to the couple that raised him adopting. Kid missed a week of school while I convinced them that he fit under a homeless youth school stability statute. Story 4. Learned while my client was on the stand that she had a little bit of a drug problem. She disclosed immediately after that she was going to fail the drug test the judge ordered because she had been a daily hard drug user for years. She was stunningly gorgeous, had held the same job for over 25 years, and was a rock star mom to a kid with special needs. Unlike 90% of my clients, she was always on time, responsive, and did everything I asked. To date, the only high-functioning hard drug user I've ever met. But yeesh, that hearing would have gone quite differently if she had mentioned that to me beforehand. FYI, most of the time we can deal with bad facts. At the very least, we can give you advice you need to hear. But there isn't much I can do with surprise facts in the middle of a trial. You would think that would be something that someone would think to tell their lawyer, huh? Although I guess if people did that, this whole thread wouldn't happen, so here we are. Story 5. I had filed a bankruptcy for a person. A few weeks later, they indicated that a creditor continued to contact them and had taken money out of their bank account, which is obviously a big no-no for people in bankruptcy. It was Monday. I knew that if I wanted to file for sanctions, I had to file the motion by Friday, so I wasn't going to jump right into it. It's best practice to try to get a creditor to correct their behavior first. I called the original payday loan store. I called the national branch. They took messages daily. Nobody was contacting me back. I asked for supervisors. Nobody was willing to talk about the situation, and I became increasingly frustrated. I'm not a yeller and I'm not particularly forceful, but even I was reaching my limit. I called my client daily to explain that it made no sense that they were being evasive, but I was working as hard as I could. On Friday, I talked to some lower-level grunt and explained that I needed a call back in an hour from a person who can clarify the situation, or the sanctions motion is being filed. I read off my time spent on the case, which would translate into thousands of dollars in sanctions if we were successful. I finally get a manager. He, very politely, tells me that the client took out the loan after the bankruptcy was filed. I remember deflating like a popped balloon. My client had taken out a relatively big payday loan a week after bankruptcy. They confessed that they knew it wasn't included in the bankruptcy, but thought that the lender would go away if an attorney got involved. That's probably mild compared to the things that I see in bankruptcy, but most I probably shouldn't disclose. One of the major tenets of bankruptcy is that a debtor has to make a full and honest disclosure of their income, expenses, assets, and debts. So, naturally, there are tons of reported cases of people hiding things to try to get out of their debts without surrendering assets. Story 6. Had a client charged with being a convicted felon in possession of a handgun. She had been in a car that had gotten into a shootout on the interstate, in the middle of the night in a rural area at least. She was the passenger, and her car pulled into the state trooper post in the county I practiced in. Her car was shot to crap, so it was obvious something happened. But there was a gun in the car. She had a 30-year-old felony theft conviction, so she was charged. She had some crazy story for what happened, but it was obvious that it was a drug deal gone wrong. However, that didn't matter for her charge, really. The discovery was really light. The driver of her car wasn't a convicted felon, and it didn't appear the state police had investigated the fact that there was another car obviously shooting at my client, even though the genesis of the shootout was just up the road in the same post's jurisdiction. Short of it was she had some legitimate defenses. I had met with her multiple times, discussed her case in depth, and was preparing for trial. About 2 weeks from trial, in passing, she mentioned that a state trooper had interviewed her at the state police post, which was annoying because at this point the case was 7 or 8 months old. So I look through the discovery again, but I don't see anything, but file a motion asking for any recordings of interviews. Sure enough, the prosecutor was sitting on it, which is shady as hell, unethical, and common practice for that prosecutor office. I get the interview, and all of 4 minutes in, she tells the cop not only did she know the gun was in the car, but she had been the one shooting. That pretty much destroyed every defense I had. We had a come-to-Jesus talk the next day, and she took her offer, which was the minimum of 5 years to serve. Story 7. I was representing a man that was accused of intimately assaulting the young daughter of his girlfriend, who was married to another man. The key issue was whether or not my client's DNA profile should have been at the scene. Only skin cell tissue had been recovered, not seminal/bodily fluid DNA. And it was not an exact match, but rather a match to a profile that included him. A few weeks before trial, he finally told me that the woman's other son was likely his. They'd been having an affair for more than 5 years. The fact that this boy shared his DNA was a pivotal reason that the DNA profile would have been present. A big issue was a language barrier, as my client did not speak English, and we used an interpreter for all of our communications. People are really not good at defending themselves, huh? That is a huge defense in terms of DNA evidence. Yes, my offspring could have been there. But no, just omitted mentioning it. Story 8. Had a guy with a DUI. Asked about any criminal history. He said no, so I started the paperwork for ARD for him. It's a first-time offense program that seals the record and drops the charges once completed. Get to the courthouse, talk to the DA, find out the guy had another DUI a year prior. Also was on probation from the first one still. His excuse for not telling me was, the first DUI was made up and he wasn't intoxicated, but pled guilty anyway. Unfortunately, I ended up representing him for both bases. Did not get paid nearly enough for the crap I went through. But I did manage to keep him out of jail so he could take care of his elderly mother. Made him give up his vehicles, though. Story 9. Spent several hours zealously arguing that my client was severely disabled and couldn't work due to a back injury. It was so bad that the poor dude couldn't even sit in a chair throughout the entire proceedings. Rest my case. Opposing counsel calls in a DEC representative who proceeds to produce record after record of my client's deer hunting activities. He sat in a tree in freezing weather for many hours, shot and unalived multiple deer, and transported their carcasses out of the woods, all on his own. SMH. Story 11. This one is the opposite of the rest, as it went in my client's favor, but I'll share it because it is a somewhat funny/happy story. I represent individuals who are applying for or have professional licenses. Nurses, doctors, real estate agents, roofers, etc. One time I was retained by a guy who was applying for a nursing license to begin his second career as a nurse. The only problem is that this guy was previously charged with murder. Not manslaughter, legit first degree. He pled down to a lesser offense. But I know that the nursing board is not going to be thrilled with the idea of giving an accused murderer, who was convicted of wrongdoing in connection with the murder, a nursing license. I talk with the client about the circumstances of the murder, hoping to get some explanation that we can use to mitigate his role or put it into context. After all, he wasn't convicted of murder, but the client's explanation isn't very helpful, and in fact makes it worse. Because in addition to someone being unalived, it was the result of a drug deal gone bad. In these types of situations, the only strategy is to take the position that your client is a changed man who made some mistakes in the past, but has since turned his life around. Given the well-known issues with race, class, policing, and the criminal justice system and so on, this strategy, if true, usually works, since everyone should be given a second chance. And denying a license to someone who is truly trying to be a better person often reinforces the cycle. So the day before the hearing, we prepare for hours, discussing how we are going to frame our case this way. On the morning of the hearing, the client was running late, so I had a bit of time before he arrived. On a whim, I decided to do a little research to see if there has ever been a similar case to this one. While precedent normally plays a big role in legal proceedings, these licensure cases are very fact-intensive and discretionary. So precedent is almost meaningless and not worth looking into. As luck would have it, my research leads me to an appellate decision featuring the co-defendants in my client's criminal case. In the appellate decision, the court spends a lot of time discussing the facts adduced at the criminal trial. My client pled out, so he was not one of the co-defendants during the trial. Each of the 4 co-defendants had a totally different story of what went down during this drug deal gone bad. None of the defendants can agree on what their roles were, who pulled a gun first, who had a gun, who shot first, who shot who, etc. However, there are 2 and only 2 things that all 4 of these co-defendants can agree upon. First, my client, who was a large, physically imposing guy, was asked to join the drug deal as the muscle, but was not really told it was a drug deal, or that guns would be involved, or that there was a possibility that it could go bad. And all he needed to do was stand there and look imposing so that no one would try anything stupid. Of course, my client probably could figure out what was going on, but these facts significantly diminished his role in everything. Second, and most importantly, all 4 co-defendants agreed that as soon as someone, they couldn't agree who, pulled a gun, my client, who was hired to be the muscle, immediately turned and ran away. In other words, as soon as there was a sign of trouble, my client absolutely noped his way out of that situation and ran like a scared rabbit. When my client arrived, I asked him why he didn't tell me these facts, since they are precisely the type of mitigating factors I was looking to uncover before. As it turns out, he was so embarrassed by the whole situation that he didn't want to tell me that part. This newly obtained information significantly helped his case, and ultimately he was given his license. And before anyone comments on how bad it is that someone like this got a professional license, I will note that by all accounts, he is a really great nurse, and truly did turn his life around. His story shows precisely why people should be given second chances in life, especially when, due to socioeconomic factors, they were never really given a first one. This guy was willing to not get a nursing license because he wanted to look cool, or at least tougher than running away. That's insane. I don't know who he was trying to impress there. Anyway, it sounds like it worked out though, so good for him. Story 11. In-house attorney here, but I interned for a judge at our court of common pleas during law school. There was a case of a guy that asked 2 early 20s girls for a ride from the mall to a gas station. He told them he would pay them cash for the trip. During that trip, he sat in the back seat and had advised that he had a pellet gun that closely resembled a handgun. He said he had only pulled it out to show the girls but never did anything further. That had been his testimony during all the proceedings. He willingly takes the stand and the prosecutor is questioning him about the gun and how he handled it. This dude willingly admits that he held it to the passenger's temple, threatening to shoot her, with what she believed to be a real gun. He also corrected the prosecutor during questioning, telling him that he never stated it wasn't a real gun. That jury verdict came about as fast as one could. Story 12. Was prosecuting a simple assault and battery. Story I get before trial is baby daddy shows up and punches new boyfriend before leaving with the kid, who, to be fair, he has custody of because mom tested positive for drugs at birth. At the time, girlfriend/baby mama tells police, yup, that's what happened. But in the meantime, she and new boyfriend broke up and she is now back with baby daddy. So her story has changed and she is saying it didn't happen. She isn't credible, so I discount her new version of events and still put the case in front of a jury. because the victim is adamant that there was an injury to his face. Defense obviously puts the girl on stand, where it first comes out that she and the victim weren't Netflix and chilling as reported to police, but were actually doing drugs and ignoring the baby. The baby daddy apparently knew that she did drugs at this location, so when he saw her car there, he went and pounded on the door demanding their kid. She then says that the victim hit himself in the face to make it look like he was beat up. As she is saying this, the victim starts hitting himself in the head and yelling "no, no, no," before storming out. The jury went with not guilty, and I understood. Story 13. So, not a lawyer yet, but I interned at a family court helping during hearings. There was this woman filing for custody of her children, and her lawyer was pretty confident they would win. Since in my country, women getting custody is almost an unspoken rule. In the rare cases they don't, they either don't want it or there's a very strong reason for the children not to be with their mother. So, as I was saying, her lawyer seemed very confident. It was a practically one case. Until her client's ex-husband mentioned in the middle of the hearing that his ex-wife was an addict and lived in a non-monogamous relationship with 2 other addicts. To make matters worse, the woman's parents confirmed his story. The lawyer very obviously did not know about it and was visibly upset at her client. I swear I saw her mouth to the woman, "You'll have to find a new lawyer." Story 14. Working on a file for a non-EU company participating in a public tender within the EU. To summarize in a nutshell, when a government agency needs to build something like a building or a bridge, they have to organize what is called a tender procedure, to weed out the charlatans and fraudsters and to enter into a contract with the most advantageous tenderer. Such a procedure is organized according to strict rules, and a lot of things are public to ensure equal opportunities for every company, and to prevent bribery, collusion, fraud, etc. Serious stuff. One of the conditions to be eligible for such a tender is that your company and its directors have not been found guilty for certain crimes. For example, breaking labor laws, money laundering, corruption, that kind of stuff, as you would be assumed to be untrustworthy. If you had such an issue in the past, you can fess up and try to argue that the risk has been completely eliminated thanks to a self-cleaning procedure, getting rid of the bad apples in your company, basically. Our client assured us that they never had such issues and were never convicted, yada yada. Just one of the many steps in a procurement procedure. Years later, when the construction was well underway, it turned out they lied, and directors in their home country had been found guilty for bribery of government officials. The contracting authority got rightfully spooked and argued our client willfully lied when tendering for the contract. The consequence is that you were never eligible in the first place and retroactively the tender should be annulled to restart the procedure. And why they didn't tell us so we could have tried to argue the self-cleaning exemption, they said it didn't seem relevant. It was widely known in newspapers, in the language of their home country, so they assumed they didn't have to tell the authorities. And besides, many CEOs in their home country get convicted of bribery, and then pardoned when the opposition party gets reelected, so what's the big deal? Literal millions of dollars and several years of thousands of people's energy down the drain. All because they lied on a form.